Hi everyone, I am Advocate Nishtha Girotra and this is lecture 3 of the Environment Law. In today's lecture, I will be talking about environment law and also a few of the basic principles of the environment law. These principles are very important as they form the base of the environment law. Secondly, we will also be seeing the formation of the codes for the environment and the factors that led to the formation of the codes, particularly for the environment, and few of the case laws along with it. So we will straight away go to the word presentation and see one by one each of the topics for today. As you can see on the screen, the first topic is the Environment Act 1986. Now, the Environment Act was enacted in the year 1986 with the objective of providing protection and preservation or the improvement of the environment. Now, in this particular act, you see the central government under Article Section 3 is charged with the mandate of preventing the environmental pollution. We have also witnessed this particular aspect in the previous lecture while we were discussing the case laws. Now, this act came up in the wake of the Bhopal gas tragedy. Okay, and post then came the Environment Protection Act. It was formed under Article 253 of the Constitution and it was passed in March 1986 and it came into being on 19 November 1986. Today it has 26 sections in it. Now this was made in order to implement the decisions of United Nations Conference on the human environment, that it leads to the protection and improvement of the human environment and prevention of hazardous activities to human beings and other living creatures, plants and property. This is an umbrella legislation, okay? This is a framework for the central government to coordinate the activities of various central and state authorities. And one thing that you should remember here is that India is the 6th largest and the 2nd fastest growing producer of the greenhouse gases emissions. So that's why it was very necessary for us to have some act like this on record. Also, three of the Indian cities are considered amongst the world's world's 10 most polluted cities. In the previous lecture, I told you the interrelationship of the environment on human being, right? Now, we saw how economy is also affected. We saw how the health is also affected. Here again, according to a report of TERI, okay, that is Tata Energy Research Institution, it was stated that India is losing about 10% of the natural income due to environment degradation. So we see the economic loss also is happening because of the environment. Another issue that we saw is the disposal of the domestic sewage. If you see class 1 cities and class 2 towns, they together generate around 29,000 mld of sewage. In comparison to it, if we see the treatment plant capacity we have is only 6,190. So you see the gap. The gap is around 7.7% gap is there in between the amount of sewage that we dispose and the plant that we have to treat it. If we add to it the plants that have come recently or that will come recently in the near future, then also there will be a gap which would be of 72.7% in sewage treatment capacity. Now this particular act, Environment Protection Act, this empowers the central government to establish authorities with the mandate of preventing the environment pollution. Now this is one of the most comprehensive legislation on the environment law. As I stated before, this has been enacted under Article 253 of the Constitution. When I talk about Constitution as stated previously in the previous lectures, I mentioned about 2 articles of the Constitution, Article 48A and 51A, which you will see mentioned in the Directive Principles of State Policy, which states that the state should endeavor in protection and safeguarding of the forest, environment, the wildlife of the country and improving the environment. Okay, so that is basically where we see in the Constitution that state has been imposed, a duty has been imposed upon the state, And then you see this particular legislation, that is Environment Protection Act, where the central government has been given the power. Okay, so that's about an introduction to the Environment Protection Act. Now we have to understand Environment Protection Act in detail. We will only be covering the important sections of it. Please open in on your systems the Environment Protection Act, or if you have the Bear Act, nothing better than that. Focus on the section 2, clause A, B and C, that I will be dealing specifically with. Okay, I'll take you to the whiteboard first. Okay, so let's go to the whiteboard to understand it. So I'll choose the color here, blue. Okay, now what you can see on the screen is basically the definition of the environment provided in the Environment Protection Act. Now see here, clause A. Environment includes, the word given here is include. Okay, we see the word here, include. And one second. Okay, anyways, here the word that you see is include. So I'll write it down here. It's include. And it includes what? It includes water, it includes air, and it includes land. This is the first aspect of it. Now see here, what we are doing here is we are basically interpreting a definition. Whenever you read any definition in your Bear Act, it is very important, or any section in your Bear Act, it is very important for you to understand the meaning, the interpretation of each and every word. That's how the courts also do it. So when you see the word water here, do not read water in a very restrictive sense, which means that water here will include within itself the underground water. It will also include reservoir and anything and everything. The same goes with the air. Air just does not include the air that you have above you, but it will include all the layers of atmosphere. When you see the word land, this is also a very elastic word. It will be used in varied senses. This is the first part of environment which we see, of section 2, clause A definition. Now what we have to see here is basically we have to see the second part of it, and the second part of it talks about the interrelationship. The interrelationship, which is an important part. I'll read the definition first. And the interrelationship which exists among and between. So you see, what are the words that have been used here? They say among and between. What was the need of putting two similar kind of words here? Among and between. Among means, what is the meaning of among? Among all of us, X is smart. Among so and so, this one is the best. Or among so and so, this is this. Okay. Between means between A and B, between X and Y. So the purpose of legislature mentioning the word among and between is that there are 8 elements mentioned here. Water, air, land, human beings, other living creatures, then you see plants, you see microorganisms, and you see property. Okay. Now, if you see the definition at the first glance, you see there's a relationship which you can see between water, air, and land and human beings. So you can easily find out that there's a relationship which we are talking with water and human being, air and human being, and land and human being. And then they say comma other living creatures, plant and microorganism and property. So it was very difficult for them to put all the permutation and combination here. That's why they use the word among in between, which means that water and other living beings, water and plants, water and microorganism, water and property, air and other living beings, air and plants, land and microorganisms, so on and so on. So all the combination. So it's an interrelationship of all of these 8 elements amongst themselves, and that is how we have to interpret the definition of the environment. Hope that is very clear to you, that the meaning of the word environment here. Now the second thing here is, you see the word includes is mentioned here. Now this particular definition is not an exhaustive definition, but it's an inclusive definition. That means that if something has to be added to it, it can be added to it. In case of confusion, since with this particular act came to implement the human laws of the environment, so therefore in case there is any confusion, then we can refer to the treaties and find the meaning to it. Okay, so this is the meaning of environment under Environment Protection Act. Now there are various sections where you will see the mentioning of this word environment in section 3 subclause other clauses, where you see central government has the power of maintaining. So you will see so many times the word environment present in your BEAR Act. It's a very important word. The next important definition here is section 2 clause B, which is environmental pollutant. Now here it means solid, liquid or gaseous substances present in such concentration as may or tend to be injurious or to environment. So they are talking about solid, liquid or gaseous substances. So they specifically talk about substances in all the 3 forms, and that concentration which may be injurious to environment today, or there is prediction or there are chances that it might be injurious. So all of those substances which we see today as injurious and tomorrow they can be injurious shall be considered under the definition of pollutant. Now the legislature has specifically chosen the word substance and not preparation here, because you will find the word preparation in the other definition, that is hazardous substances. You will see the preparation word there. So the preparation of these substances which are solid, liquid and gaseous, and that the concentration is it's injurious to the environment, is being it has to be regulated. So word preparation, you will find it there. Now the next definition is section 2C, which is environmental pollution. Environmental pollution means the presence in the environment of any environmental pollutant. Now this is a very fascinating definition, which in itself has the definition of word environment, and it also has the word environment pollutant. So these two together, the combination of environment and environment pollutant together makes the environment pollution. Okay, now I'll go back to the word presentation and we will see, I'll discuss with you some of the important other definitions, and then we'll move to the next topic. Now, if you have the BEAR Act open or you have it in your system open, you should see the word section 2D, which talks about handling. Now by handling it means any substance, manufacturing, processing, treatment, package, storage, transportation, conversion, offering for sale and all these substances. Okay, so it means here handling means this. 2E talks about your hazardous substance, which means any substance or preparation. You see the word preparation mentioned here, which by reason of its handling is liable to cause harm to human beings and other living creatures, microorganism, property or environment. To handle is another word that you see, which should be read in consonance with the word handling here. Now this is about, or in detail if you want to know about the hazardous substance, you can read more about it, which talks about the chemical or the physiochemical preparation, environment pollutant. So this is in short about the Environment Protection Act, the major and the main definitions of it, and the most comprehensive act. Okay, so with this we finish the introduction to the Environment Protection Act. The next topic that we have to see here today is environment audit. Now you must have heard audit when you read about the finance part of it, when you read about the corporate law, the business laws, the Companies Act, you see the income tax, you see the audit part there. Now what is the meaning of audit here? Environment auditing is also something which began creating towards the start of 70s of the previous century in United States of America and Western Europe. It started there. Now in that period, nations were embracing the natural enactment as to decrease the unsafe result of the organization that were affecting the environment. Okay, now we wanted to assess it so that we can decrease the harming impact on the nature in an effective and money saving advantage way. And to do that, there came a concept of environment audit or environmental auditing. Now, the meaning of environmental auditing, as you can see on your screen, is the executive's instrument includes methodical, reported, occasional, targeted assessment of how well the administration frameworks are performing with the point of waste counteractive action, assessing consistency with administrative prerequisites, facilitating control of ecological practices. So it's basically an assessment that is done. Okay, and if you just open the news, type in the Google environment audit, you will see a lot of news around it. Recently there was an audit for the sand mines. Somebody in South had Kerala or somewhere, they had requested for a virtual audit, which was very necessary for the environment while the pandemic was going on. Then if there is a construction that is happening, then there is an assessment. If there's an industry, then there is assessment. I'll tell you what's happening recently. Now coming to India, now the legislature of India, by the newspaper notice, made it compulsory for all ventures to give yearly natural review reports of their staff starting with 1992-1993. These expected enterprises to give subtleties of water, crude materials, vitality assessed, utilized, and the items quantities produced by them. Okay, now these reports were to be submitted to the State Pollution Control Board or on or before September 30th. Okay, now ecological review did not get acknowledgement from the industries. Business were having run down. So what was happening was basically we implemented the environment audit, but effectively it was not happening. Okay, the businesses were saying that the modus operandi of the environment audit is not completed. There are a lot of hassles when we go for the environment audit, and there should be some changes that should be brought in. Okay, a sufficient number of ecological auditors are not accessible, environmental reviews are tedious and costly. Okay, so that's what was happening, and the government is trying even today to have a very good audit system, because it really helps in assessment of what is happening and how it should be prevented. Now let's see the news. It's given in your notes, I've put in there. Now the State Mining Corporation Limited is conducting environment audit in accordance with the central government's Environmental Guide 2020 to prevent illegal mining in the state. Okay. Now the officials are claiming that the environmental rules for sand mining compliance is very important, and therefore the audits of all the ghats of the Bihar has been started. Now there's an international also of Islamabad. The Climate Change Ministry would rather put efforts to ensure environmental audit of housing schemes with the aim to protect natural environment in the face of increasing construction activities. So to assess it, that's an order that's been given in Islamabad also. Now there's a report. There was an audit of 19 states. 7 civil society organizations have found a clutch of popular FMCG brands including Parle Products, ITC, Britannia, Haldiram, Tata Consumer, Milk Mist, United Spirits to be among India's top plastic polluters. So we are trying to control plastic pollution, okay, because plastic is very dangerous for the earth. Now this report was released on November 18, and 1,000 volunteers of 6 organizations part of global conglomeration called Break Free from Plastic conducted the audit, including by collecting plastic waste from two sources, homes and public spaces. Now see what happens. They collected 1,49,985 pieces. 61% of them was from food packaging. Out of this, 21% was from the milk alone. 18% was used for packaging plastic material. 8% personal care, 7% for household product, and 1% for smoking material. Now, these important companies which were included in it were Unilever, PepsiCo, Coca-Cola, Nestle, Amazon, and all of them. So they all are the contributors. So now what has this assessment helped us? This particular audit has helped us to understand the waste generation, the plastic pollutant in the environment, and how it is created and how it can be reduced. And according to this assessment, certain guidelines are made and things are checked. That's about the environment audit. To you few of the recent events which have happened around environment audit in India. Okay, just listen to it. NGT has asked CPCB, okay, that is the Pollution Control Board, the Central Pollution Control Board, to consider environment audit of Amazon, Flipkart, PepsiCo, etc. Okay, Supreme Court orders. Then there's an auditing of other places also. There's an order that auditing should be carried in respect of few of the industries to see how the pollution can be decreased. Another important topic here is eco mark. You must all have seen certain eco marks like these, which have become very famous. Now, what are eco marks? How does it help the consumer? How the eco labeling has been effective? When it was launched, we will see in the eco mark. Now, when I talk about eco mark, this is basically is done to implement the environment policy again. Okay, and okay. So eco-mark was basically brought in to preserve the environment. It's a way of protecting the environment, and the eco labels became very important since the year the scheme was launched in the year 1991. And this basically what happened was there were certain products that were sold in the market, and now they were supposed to have an eco label. Now, eco label just differentiated and helped the consumer on one hand to know which is non-toxic, which is biodegradable, and so and so. And on the other hand, it also helped us to preserve the environment. Okay, so you see that there are a lot of products where today we see a lot of eco labeling on it. Now, the eco labeling objective did not become very successful initially, but started picking up later. It's only in the few areas that we see pulp and other areas where we see eco labeling as very famous. Now, in 1991, one of the major factors behind the constitution of this scheme was Menka Gandhi. Okay, she's also an environment activist. Okay, so Kamal Nath, the immediate successor, was also supportive of the scheme. Okay, and after that, nobody showed very much interest in the eco-mark scheme, so it did not become very much successful. Now, if we want to see what is the major objective behind the eco-mark scheme, the objective is to provide an incentive for manufacturers to reduce the adverse environmental impact of the product. So if they say that, suppose if it is environment certified or has an eco label, then you might get certain schemes and all of it. Okay, and sometimes this eco mark is also to reward the genuine initiatives which are taken by the communities, by the companies, to reduce the environment impact. It also helps and assists the consumers to become environmentally responsible by providing sufficient information, and it helps the consumers, to buy those products which are less harmful. It helps, in short, to improve the quality of the environment, and it helps to encourage the sustainable management of resources. This is the reason behind the eco mark labeling. Okay, now After the eco mark labeling, what we have to see is the environment code. Now the environment code, the coming of the environment code has a history in it. Okay, we'll see one by one. There's a chart made on your in this on your screen that you can see. In 1987, if you see, then the Supreme Court was first convinced of the need for scientific and technological expertise in the area of environment, and therefore urged the government to set up the Ecological Science Research Group. This was in 1987 when they felt the need of the environment, and they came up with the Ecological Science Research Group. Now in 1987 itself, in the case of MC Mehta versus Union of India, it was stated that since the cases involving the issue of the environment pollution, ecological destruction and conflicts over the natural resources are increasing, coming for the education, these assessment involving scientific and technical data, it would be desirable to set up an environment courts. So when they saw the flooding of the cases which were related to the environment, this is the first time they felt that the environmental code should be set up. Now in 1996, in the case of Vellore citizen case, Supreme Court requested the Chief Justice of Madras to set up a green bench. Now by then the green bench was set up in all the courts which were hearing the environment matters. This was already done in Calcutta, Madhya Pradesh, Punjab and Haryana. Now in 1996, in the case of Indian Council for Enviro Legal Action versus Union of India, the Supreme Court said that whenever there is a case related to the environment, it should first be heard by the High Court, which has the territorial jurisdiction. Territorial jurisdiction, and that means the place where certain activity like this of environment has taken place, or there's an issue related to the environment in that particular area, in that particular territory. Okay. For example, if something happens in Delhi related to the environment, then it will go to the Delhi High Court. Okay, that's called the territorial jurisdiction. Now, the Apex Court also reiterated the need for creating environmental courts to deal with all matters civil and criminal and relating to the environment. Now in 1999, AP Pollution Control Board versus MV Naidu, Supreme Court here again expressed the need of establishment of environment court consisting of judicial and scientific expertise. It suggested amendments in the environment statutes to ensure that all environment courts, tribunals and appellate authorities, there's always a judge of a rank of a high court judge, sitting or retired scientist, like appellate authority under an environment appellate authority. So there was an environment appellate authority created. Now what happens in these tribunals is basically you have one judge and you also have a technical member. Now technical member is required because aspects like these of environment involves a lot of scientific knowledge in that particular area. So when bench comprises of both a judicial person as well as a technical member, it's very helpful in matters like this. On January 30, 1997, President promulgated an ordinance to establish National Environment Appellate Authority to hear appeals in respect to restriction in areas in which the industry's operational processes shall not be carried out or shall be carried out subject to certain safeguards. Okay, so that's how the history of the setting up of the environmental courts. Now the next important principle here is polluter pay principle, which is very famous and it is very much in news these days also. Okay, now the principle behind this particular principle is that who should pay for the damage. Suppose Bhopal gas tragedy happened, a lot of people suffered. Who should pay to this about this damage? Okay, now this damage can be to body, society and environment. Now, in order to have a balance between the development and the environment protection, this particular concept of sustainable development was introduced. Okay, now it was very difficult to keep a check on these harmful activities as to who should be penalized for it, on the introduction of penalty on the harm of the environment. So polluters pay principle came. Now this principle means that the cost of pollution should be paid by the polluters and not the government. The principle is considered to be the most efficient environment policy and has been included in various regional and international agreements on pollution. So suppose I'm opening an industry here today, I will be responsible in case certain things, certain anything like any damage is caused to the environment or the people, then the cost is incurred by the people who are the reason behind causing of this particular pollution. Okay. Now, polluters pay principle was also brought in the Stockholm Declaration of 1947. Okay. And in India, it came in 1996 in the Indian Council for Enviro Legal versus Union of India. And in this case, the court came up with the concept of absolute liability, that is MC Mehta versus Union of India, also known as oleum gas leak case, okay, where the court said that the polluter pay principle demands the financial cost of preventing, remedying damage by pollution should lie with the undertakings which cause the pollution, produce the goods which cause the pollution. Under this, it was stated that it is not the role of government to meet the cost involved in the prevention of the damage that is caused because of the pollution. Now, another principle is the precautionary principle. Precautionary principle, as the name suggests, is about precaution. It encourages policies that protect human health and environment in the face of uncertain risk. Okay, this is not a new concept and it's a very old concept here. So this principle, as the name suggests, means that whenever you see that there is certain harm that shall be caused to the environment or the people, then certain precautionary things or actions should be taken, okay, in that particular area. Now the word precautionary principle has come from the German word which means foresight principle, okay, and this means that taking preventive action in the face of uncertainty, shifting the burden of proof to the proponents of the activity. So these are the two basic principles here. So in this particular lecture, we have seen the development of the codes. We see the Environment Protection Act, the polluter pay principles, the precautionary principle, eco-mark, and the environment auditing. Before we finish this lecture, there are certain other things that you should know. Regarding the precautionary principle, there are a few important things. So the essential ingredients of the precautionary principles are the environmental measures. Okay, so the state government and the statutory authorities have to basically, they must participate and they must prevent and attack the cause of environmental degradation. So that means that whenever they see that there is a threat or there is an irreversible damage, okay, and lack of scientific certainty, okay, should not be used for postponing the measures to prevent environmental degradation. So suppose you see that there is a reason and because of this the environment can be degraded. So now the government has to take effective steps to mitigate that particular degradation that is going to happen. That is called precautionary principle. To understand this in a better way, I will put it in short words, which means that reversal of it. Now, there was a very famous case called MC Mehta CNG vehicle case, AIR 2002-1969. Now, because of there was certain auto policy which was made. There was certain environmental impact that was being caused on the air because the air was being impacted. And then the court observed that the government has to stipulate certain norms, and there are certain norms that are already there which have not been effective in controlling the air pollution. So therefore there was a constitutional duty which was casted upon the government to protect it, and this precautionary principle came up with, okay, so there are certain more duties that were casted, statutory duties that were casted upon the government to mitigate these risks. This is basically the precautionary principle. Now, when it comes to the polluter pay principle, there are certain cases which you can note down. One is Calcutta Tanneries case, where the task of assessment and recovery of restoration cost was assigned to the authority appointed by the state government. Then there is one important another case where which is called MC Mehta versus Kamal Nath Span Motel case, where there was a news item which appeared in the Indian Express that was a lease was granted by the state government for commercial purposes, and Okay, and basically the mortal management interfered with the natural flow of river, and therefore they were asked to mitigate this, and they were asked to protect the environment and asked to pay for the same. There was penalty imposed on them. So such way the polluters, so whosoever pollutes us has to compensate for the same. This is about the polluters pay principle. In the next lecture, we will see a few of the cases in detail, discussing about the Constitution of India and the environment, and we will see one by one how the Constitution is effectively involved in the preservation of the environment.